Begin. So welcome to the first debate on private law, jointly organized by the Center for Private Law and the Law and Technology Center. And I really like this format a lot because we have a proper joinder of issues. Question today is, should the law recognize property rights in digital files? Saying yes, on my left is Dave Michels. Dave Michels is a researcher of the Cloud Legal Project at the Center for Commercial Law Studies at Queen Mary University of London and a guest teacher at the London School of Economics. And responding on the right, basically saying no, is Professor Kelvin Low. Professor Kelvin Low is very familiar to all of us. He's a graduate of the National University of Singapore and Oxford University, and is currently a professor at the University of Hong Kong Faculty of Law. So without further ado, Dave, you're up. It's working.
Beautiful. So good afternoon. My name is Dave Michels, and I'm here to talk to you today about the question of property rights in digital files. But first, I'll just briefly introduce myself. I'm a researcher and PhD candidate with the Cloud Legal Project at Queen Mary University of London. And our research is funded by Microsoft. I also teach. I teach cloud computing law both at Queen Mary and at the LSE. And I'm here today as a visiting fellow to the University of Hong Kong at the invitation of Professor Kelvin Low, to whom I am truly grateful. Kelvin, thank you for this opportunity to come here and talk about my research. And thank you also for all of your work on digital assets, from which I've learned a great deal. It's really helped me refine my position. So let's talk about that position then. I am here today to present a simple proposal, which is that the English common law should recognize an in rem property right to digital files in order to protect control over digital files from third-party interference by offering a remedy for return or damages. And it should do so in order to promote human flourishing in cyberspace. So in essence, my proposal has three parts: a right, a remedy, and a reason. Now, I should clarify that when I say digital files, I'm talking about all of the Word documents and Excel files and digital photographs that we create in our daily lives. Essentially, they are digital collections of information that are presented to us as users of computer systems as individual files with distinct file names and locations. So what am I going to cover in my presentation today? Well, I'll start with this proposal for a property right and an associated remedy. And then I want to touch a little bit upon the concept of rivalrousness and how it might apply to digital files. And finally, I'll talk a little bit more about the reason for my proposal, right? The normative basis upon which we should extend protection to digital files. It'll take about 25 minutes. Okay, so what do I mean when I say we should have an in rem property right and a remedy to digital files? Well, what I'm really talking about is a control-based possessory title that protects your control over your digital files from third-party interference. In essence, I propose that our digital files enjoy the same type of protection as the physical objects that we possess. And in my proposal, this notion of digital control plays the role that physical possession plays under the law for physical objects. So at heart, this is an argument of functional equivalence. It is the argument that we can take the rules that have traditionally governed our interactions in the physical environment and apply them to the online environment, right? Or as Schellekens put it, it's the idea that what holds offline should also hold online, right? We can use these same established principles, in this case of property law, to govern our online interactions. Because doing so allows us to resolve conflicts in a way that balances competing interests, just as it does for our physical objects. So at heart, this is really an argument based on the general maxim of justice that like cases should be treated alike. And that, I think, highlights the key question for this debate. Are these like cases? Right? Are our digital files like our physical objects in relevant ways, such that we can apply the same rules? Or are they in fact different? I will argue that they are. Kelvin's opinion may well differ. So let's start then by reminding ourselves of how the law treats our physical objects, which are called things in possession. Does anybody know what this is? Crown, very good. That is exactly right. More specifically, it is the Queen Mother's crown, right? It is part of the British royal family's collection of crown jewels, and as such, it is the property of His Majesty King Charles II. Now, this crown is extra special because it contains one of the world's largest and most famous diamonds, the Koh-i-Noor, which weighs in at just over 20 grams and is valued at hundreds of millions of pounds. So it's clearly a physical object of great value. And as such, it can be subject to possession, right? In practice, King Charles can possess the crown in one of two ways. He can exercise direct control over the crown by holding it in his hands, or he can exercise indirect control over the crown. For example, he can store it at the Tower of London in a locked room and make sure that only he has access to the key. In that way, he has indirect control over the crown because he controls the means of access. So under English law, that fact of possession gives rise to a possessory title. And the person with the possessory title is entitled to peaceful enjoyment of the thing which they possess. At the same time, the law imposes upon all others a duty not to interfere with that possession. And that duty applies to everyone, which is also referred to by the Latin phrase erga omnes. Now, anybody who breaches that duty, who interferes with a person's possession, commits a wrong. And one of the wrongs is the tort of conversion. Now, conversion is when you deliberately interfere with someone else's possession completely. The classic examples of conversion are taking somebody else's thing or destroying it. Now, in case of conversion, specifically in case of taking, the original possessor has a right to a self-help remedy in the form of recaption. That is, I can take my thing back if you've taken it from me without committing a wrong. So that's one option, to seek the return of your thing. Alternatively, you can take legal action, right? You can call upon a remedy before the courts and ask them to order whoever's taken your thing to return it to you or to pay damages. So let's look at a practical example of how that might work out in practice. So we have King Charles and we have the Queen Mother's crown, right? And King Charles keeps the crown at the Tower of London under lock and key. But Bob has his eye on that diamond. He wants the Koh-i-Noor. Now, let's assume that Bob manages somehow to take the key from King Charles, right? He sneaks into the Tower of London and he takes the crown. What the law does is it gives King Charles a remedy to sue Bob and demand a court order that the crown be returned to him. or that Bob pay him damages. So far, so straightforward, right? Things in possession under property law. Now, I would argue that we can apply these same concepts to our digital files. And that is largely because of the security measures that are part of modern computer systems. For example, think about the files you have stored on your local device, like the laptop you might have brought with you today. If you want to access those files, you have to log in through your Windows or Mac OS account. Similarly, when it comes to the files that you've stored in the cloud, you'll need to log in through your Microsoft or Google Cloud Service account. In both of those cases, you'll need to identify yourself to the system through some form of multi-factor authentication, right? You'll need to provide a password that only you know, or you'll use your biometrics, like a fingerprint or a face scan, or you might use a one-time code that is sent to your device or to your email. In addition, you might apply encryption to your files in order to prevent others from accessing their contents. Or you might put in place a password for a specific file, right? So that anybody who wants to open that file needs to additionally fill in that password. All of these security measures allow us to exercise control over our digital files. And specifically, we can use that control to exclude all others, right? I can access the files I've stored on my laptop. You cannot. Unless I decide to share access with you, right? I can use access privileges to share documents with others. For example, that's how we co-author documents in Microsoft Teams, right? We can work together on a document and I can say, give Grace access privileges and allow her account to see my document and maybe even to edit it. Similarly, that's how I would share photographs with my family in Apple iCloud. So I would argue that this digital control over our files is similar to the way in which we exercise physical possession over the tangible objects that we own. In particular, it's like storing things in a locked room. The password to your computer is like the key to your apartment. And in the same way that the digital control is similar to physical control, they're also both subject to the same kinds of third-party interference. More specifically, somebody can take control over your digital files or destroy them. Let's look at a practical example. Say Alice has stored a file in the cloud, and she's protected her cloud service account with a password, which in her case is password 1234, which is not a good password. Enter Bob, right? Bob has his eyes on Alice's digital file. He manages either to guess the password or somehow, in some way, finds out what her password is. He can now access Alice's file. And if he changes the password, then he effectively prevents her from accessing the digital file, right? He now controls it. And in a worst case scenario, he might delete that file from the cloud server. I would argue that this interference is similar to what we discussed with King Charles's crown, such that Alice should also have access to a legal remedy under property law. Right? Whenever Bob takes control of Alice's file, she should enjoy the same legal protections that she has for her physical objects. That is, she should have a right of recaption to take the file back from Bob without committing a wrong, and she should be able to call upon remedies for the tort of conversion, for the return of her file, or for damages. That's the simple bit of my proposal. Here's where it gets complicated. There is a clear difference here between physical objects and digital files, which is important to recognize. Right? Digital files can be copied in a way that we can't really do for physical objects. This means that Alice and Bob could easily enjoy equal access to the file, right? They could each have a copy of the file. And so this calls into question, for some authors, the rivalrousness of digital files. For example, the Law Commission of England and Wales argues that digital files are non-rivals, and so they cannot attract a property right. In other words, this is an argument which says that these are not like cases. Digital files are too different from physical objects to attract property rights because of their non-rivalrousness. So that takes me to the second part of my presentation. Rivalrousness. So the Law Commission of England and Wales explains that a thing is rivalrous if the use of the thing by one person or a specific group of persons necessarily prejudices the use of that thing by other persons. And this is pretty easy to apply to the possession of physical things, right? We think about a ring, as Bridge points out, a diamond ring cannot support two wearers at the same time. Or as Smith and Newman put it, either I am using the hammer or you are. I approach the concept of rivalrousness slightly different from the Law Commission. And to illustrate that, I'd like to think of our practical example again. It's certainly possible to use a crown in a rivalrous way. For example, only one person can wear a crown at any given time, right? This is a picture of Queen Mary, after who my university is named, at King Edward's coronation in 1911. Here she is wearing a crown with the Koh-i-Noor in it. Clearly, only one person can wear a crown at any given time. But that's not the only way we can use a crown. You can also display a crown in a museum. In fact, that is what the royal family does with the Queen Mother's crown. It is on display in the Tower of London. And any number of people can look at a crown at any given time, right? In fact, hundreds of tourists do on a daily basis. They go into the Tower of London and they look at this beautiful crown. So I would argue that things are not rivalrous or non-rivalrous. Instead, we can put things to rivalrous or non-rivalrous uses. And that control over how we use our things, that is rivalrous, right? You cannot wear a crown and display it in a museum at the same time. Those things are mutually exclusive. And so it is the possessor who has the right to decide on the use of their things. And that possession of tangible objects is what is rivalrous. And I would apply the same argument to digital files, right? You can use digital files in non-rivalrous ways. You can share copies of your digital file with everyone in this room, and then we can all enjoy access at the same time. But you can also use digital files in rivalrous ways. I think editing files is the clearest example of that. We think about writing a Word document, preparing a set of PowerPoint slides, or editing an image in Photoshop. Only one person can do that at any given time for that to be a meaningful exercise, right? We cannot all write the same Word document at the same time. In other words, a Word document does not permit two rival authors at the same time. We can work together on a Word document. We can have a group of editors working together at the same time, but we cannot have rival groups editing the same digital file at the same time, because doing so would result in conflicting edits that would render the file useless. put it in the Law Commission's language, I would argue that the editing of a digital file by one person or a group of persons necessarily prejudices the editing of that file by others. Or simply put, either I am populating this Excel sheet or you are. And so I would argue that just as our physical things, files are not rivalrous or non-rivalrous. They can be put to rivalrous or non-rivalrous use. And that decision over how we use our files, that is rivalrous, right? We can decide to share them widely and give everyone copies, or we can decide to impose access restrictions. But we cannot do both at the same time, right? A file cannot be both password protected and not protected, or both encrypted and not encrypted at the same time. And so, as it is with possession, so it is with digital control. Control over digital files is rivalrous. So it's true to say that Alice and Bob could share access to the same digital file at the same time. But whether they do should be Alice's decision. So to sum up my proposal then, I would say that digital files are like physical things because they can be subject to digital control over use in rivalrous ways. And it's also possible for third parties to interfere with that control. And the law should respond by offering a remedy for return or damages. So that's a lot about rivalrousness. For the final part of my presentation, I'd like to turn to the reason for this protection, right? Why should we do this? And I argue that the law should offer the same kind of protection for the same reason, which is to create the conditions for human flourishing. That's a rather grand claim. So let's see what I mean by that in practice. Again, I think it's helpful to look to the existing law and look at the normative basis for protecting possession to physical things, right? We can think of the right to property as a right to liberty. As Penner puts it, property gives each of us a protected sphere of indefinite and undefined activity within which we can do with the things that we possess whatever we choose within the limits of the law. And this protects the exercise of our natural powers, our intellectual and physical capabilities. In other words, property gives us a freedom to act through the objects that we possess, to use them in ways of our choosing, free from outside interference. As Classe puts it, private property provides the material basis for exercising individual agency. And that gives each person a level of control over their own life. It allows each of us to function as a free and autonomous agent. By that, I mean we are free to set our own goals, to choose our own means, and to act upon those choices, including by acting through the things that we possess, without having third parties interfere with our enjoyment of our things. This builds on earlier work by Martha Nussbaum, which argues that property rights give individuals a level of control over their environment. And that, in turn, allows them to express their capabilities. It allows them to engage in practical reason, to use their imagination, and to engage in all sorts of acts of self-expression. That lets us live what she calls a fully human life. It provides the conditions for human flourish. Now, of course, this does assume that you have some level of possession that is worth protecting, right? You need to have some objects to act through in order to self-express. But this argument is not about the distribution of assets throughout a society, right? That is a separate question of public policy. The point here is simply that each of us has an equal right to the peaceful enjoyment of our things, right? Whether you have a crown or a baseball cap, you have the right to use that thing in ways of your choosing, free from third-party interference. And so I would argue that that same normative basis for protection applies to our digital files, right? Digital files are tools for self-expression. We can use them to store and edit and share information with others. This allows us to exercise our reason, use our imagination, and build relationships, to engage in academic, artistic, and commercial pursuits of our choosing. That value is worth protecting online just as it is offline. We should all be entitled to the peaceful enjoyment of our things, whether those things are diamonds or digital files. That allows us to express our capabilities and provides the conditions for human flourishing in cyberspace. So that's what I wanted to say for today's presentation. I hope that's helped clarify my proposal for an in-rem property right to digital files that protects your digital files from third-party interference through a remedy for return or damages, and does so in order to promote human flourishing in cyberspace. I hope that this proposal can help you think about ways in which we can extend property rights to digital files. So all that remains for me is to thank you for listening. Thank you again, Kelvin, for inviting me. This is research in progress for us. We hope to have a draft paper ready for SSRN by the end of the year. If you're interested in our research, please do add me on LinkedIn. Thanks again for your time. I look forward to hearing what Kelvin has to say, and I look forward to answering your questions.
Thank you so much, Dave. I guess now we'll hear argument from the respondent, Professor Loh. So Kelvin, please.
Okay, so thank you, Dave, for a very clear and interesting presentation. Your views have evolved from the paper I was responding to. So to the audience, I'm not going to respond exactly to what Dave presented because I only saw his slides today. So some of what I'm going to say is actually responding to his earlier paper, but I will also try to respond to what he has just said earlier. Before we begin, I should tell you a little bit about my research background. Unlike Dave, who comes from the digital side of legal research, I come from the property law side, right? So I research both real property and personal property. And when you look at digital files as a property lawyer, things look very different. So first question, what is property? So very recently, Sir Roy Good in the LQR suggested that subject to statute, property is anything of realizable commercial value. This is the sort of perspective I would expect to see from a commercial lawyer. If people buy and sell things, that is property. However, you're familiar with this quote from Shakespeare, all that glisters is not gold. I have adapted that. Just as all that glitters is not gold, not everything that is valuable is the subject of a property right. It may be protected by contract or some other legal right other than property, or even completely unprotected. So for example, personality rights. This is regarded in America as property, in England, unprotected, all right? Now, and conversely, as I have also stated with a different co-author, objects may or may not be valuable. Literal shit is property, all right? So most of us have produced property today. I hope, right? The absence of value has no bearing on their status as property. Now, at this point, I need to clarify some terminological confusions because the common law, because of the use of the English language, is one of the more confusing legal systems when it comes to the law of property. So when I teach property law, or at least if I teach the first part of property law, I always start with this diagram. So most of us, when we learn property law, we are told rights are divided into personal rights or property rights. If you prefer the Latin, rights in personam or rights in rem, right? So rights in personam are by definition not rights in rem and vice versa. We are then told that in English law, we divide property into real property and personal property. Real property is property you can obtain the return of via a real action, which nobody uses anymore. Personal property is that which you can't. Okay, so real property then gets divided into corporeal and incorporeal hereditaments, and personal property into things in possession and things in action. I'm not going to go into the third thing debate that's peculiar to England. Now, there is something wrong with this picture, and I always ask my students, point out the mistake. We don't have time, so I will tell you where the mistake is. The mistake is highlighted in red. Okay, your classical thing in action is your contractual debt, and your contractual debt is a personal right. You cannot have a classificatory system whereby the same thing appears on both sides of the classification, right? So personal rights cannot be property. So what has gone wrong here? What has gone wrong is this. If you look at the top half of the diagram, when we talk about property rights there, we are talking about property as in rem rights. Now, I just add that there are other things other than in rem and in personam rights. We have what I call abstract erga omnes rights. Copyright, patents, these are abstract erga omnes rights that are no res. Okay. Now, since we are in Hong Kong, Hong Kong is a part of China, I like to use Germanic systems to highlight the differences. In Chinese law, in this part of the diagram, we would describe these as wu quan or mat quan. Okay. Now, we come down to the bottom half of the diagram. At this point, we are talking about a different conception of property. We're talking about property as wealth, transferable wealth. And in Germanic systems, again, to use Chinese, this would be a different word. This would be 财产 or 财产. All right. Now notice 物权 and 财产 are not the same word. Although in English, we use the same word for both concepts. Okay. So basically what originally looked like one master diagram is actually two. And the word property in both parts, both diagrams, actually mean completely different things. One is an in rem right, one is transferable wealth. And so if you use different terminology, you are less likely to get confused. But if you use the same word, you are very apt to get confused. And we've seen very many people make this mistake. Every time you see somebody write an article saying we should apply the tort of conversion to contractual rights because contractual rights are property and conversion is a property tort, they are making this mistake. Okay? So it gets actually even more confusing. So let's diagrammatically represent these various rights. If we live in a very small world where there are only 8 people who are very unimaginatively named A to H, and there is a violin, and you have an in rem right over this violin, let's say A owns the violin, A has the right to exclude B through H from interfering with his possession of the violin. All right? So we are talking about the right, which actually in Chinese, the reason why you have the word quan in there refers to the right. It's literally in rem right. Okay. Now, if you're talking about property as wealth, then things in action, even contractual things in action, your bank accounts, which are basically debt claims against your bank, these are wealth, right? In fact, most wealth today is intangible, and therefore most wealth today is in choses in action, right? Now, finally, if you're talking about the thing itself, rather than the in rem right, so you're talking about property in the colloquial sense of the word, then it's just wu or mat. There's no kun in there. There's no quan. So you need to distinguish three different things: wu quan, wu, and cai cai. These are three conceptually different things. Now, why is it important to distinguish between things and what I call legal property or in rem rights? As Rob Stevens has observed in his article, Crypto is Not Property, the moon and the fish in the sea are things, but they are not property. Okay, we are lawyers. We are not physicists. We're not biologists. We're not chemists. We're interested in relationships with things. We're not interested in things themselves. There are plenty of things that are unknown, right? Nobody owns the moon. Nobody owns the wild fish in the sea, right? So they are property in the colloquial sense. They are not property in the legal sense, okay? Now I have an even better example. Running water is incapable of being owned in and of itself, okay? And the reason we know this is if you're into land law like I am, if your neighbor gives you a right to go onto his land to take water, this can only exist as an easement, not as a profit. If your neighbor gives you the right to go onto his land to collect firewood, then it could be a profit. The reason being, in order to acquire legal property over water, you have to use a container to take possession of it, right? Hence, just because something exists, just because something is rivalrous is irrelevant. The question is, do you have a rivalrous relationship with the thing? And this is where I sort of object to the Law Commission's use of rivalrousness, right? The Law Commission focuses on whether the thing is rivalrous. On this, I think Dave and I agree this is wrong, right? But where Dave and I disagree is, I don't agree that use has anything to do with it, okay? So Dave used the crown, I'm going to use something else. But before that, I also need to distinguish the kind of control Dave is talking about. Dave uses passwords as a form of control, right? Now, password control is what? It's information. Your password is information. Information is by definition non-rivalrous. If you keep your password secret, you have rivalrous control. But if you fail to keep it secret, then you don't have rivalrous control, right? It is conditionally rivalrous. It's almost rivalrous, but almost rivalrous is a bit like being almost pregnant. Right? When your doctor tells you you're almost pregnant, it means you're not, right? Not really. So the Mona Lisa, right? If you possess the Mona Lisa, you're hanging on to it, then you have rivalrous control over the Mona Lisa. But as Dave rightly points out, if you hang the Mona Lisa up, any number of us, in fact, lots and lots of people, hundreds, thousands of people every day at the Louvre enjoy the Mona Lisa. Right? And very importantly, the law is not concerned about use, right? Many chattels are used not through possession. Paintings, I mean, nobody enjoys a painting by, hanging onto it and waving it around, right? Unless you're very weird, right? You enjoy a painting by looking at it, right? Certain objects, their natural use, if you will, is non-rivalrous. The law is only concerned with possession. Now, why is possession special? Possession is special, and therefore things in possession are special because what the law is trying to do is replicate a naturally rivalrous state of affair. right? So the law protects you, the owner of a chattel, from interferences with possession, not interferences with use, interferences with possession, all right? And therefore, you have a neat, natural barrier. You know what you can, you know what you can't do. The problem, and I don't have a problem necessarily with the law wanting to create rights in relation to digital files. It's just that there is no natural boundary. Why do you say you can do this, you can't do that? Right? It's up to the law. The law has to decide what sort of rights, what sort of exclusive rights do I want to give the quote unquote holder, owner of the digital file. There is no natural barrier to replicate. You are creating the rights de novo. Okay. Now, one of the reasons why we instinctively gravitate to this idea that digital files are a bit like objects is the prevalence of metaphorical thinking amongst humanity. We think a lot in metaphors. So I don't know how many of you are familiar with this very famous book from social science in the 1980s by George Lakoff and Mark Johnson called Metaphors We Live By. So according to Lakoff and Johnson, conceptual metaphors shape not just the way we communicate. So most of us think of metaphors as just, linguistic flourish, but it actually influences the way we think and act, right? Now, what is a metaphor? The essence of a metaphor is understanding and experiencing one kind of thing in terms of another. So, for example, argument is war, time is money, right? So these are metaphors we would all have come across. However, and importantly, metaphorical structuring is necessarily partial, not total. Because if it was total, you would be talking about the same concept, right? So, for example, time isn't really money. If you spend your time trying to do something and it doesn't work, you can't get your time back. Right? You can get an equivalent amount of time. You can't get your time back. Right? You could get your money back. Now, what does this have to do with digital files? Well, if you look at the language we use in computing, you will find a lot of metaphors. Why are files called files? Why do we have folders? These are metaphorical language. You could have called them anything you want. Didn't have to call them files, didn't have to call them folders. For some reason, I don't know why, computer scientists love metaphors. So I don't know whether you have heard of Byzantine fault tolerance. The reason we have something called Byzantine fault tolerance is because a couple of computer scientists in 1982 wrote an article about malfunctioning computer nodes, and instead of talking about malfunctioning computer nodes, they used the example of traitorous Byzantine generals. That's why we have Byzantine fault tolerance. Now, not only is the language misleading, the graphical user interface with which we are trained to use computers, most of us don't use command prompt, right? Creates this impression that they're actually files and they're moving from folder to folder. Now, this is not true. And you know it's not true if you try to move a lot of files, let's say 10 terabytes of files, from one folder in the same medium to a different folder in the same medium. It is instantaneous. Why? Because nothing is moving. All that is changing is the file path location. Right? That's why it's instantaneous. Now, not only is what we see misleading, what we don't see is also misleading. So, for example, if you were to write a novel, right, and take a pen, you put it on paper, nobody would think the words have a separate existence from the paper, right? Nobody does. Well, because, if you go back to Roman law, this is the process of accession. The ink used to exist as a separate thing. You apply it to paper. It's now part of the paper. No more ink. And certainly you don't own words either. Now, this is despite the fact that we can now technically remove the ink and move it onto a different piece of paper. There's actually a case in Canada, where there was a copyright infringement action brought by the plaintiff against someone that removed his artwork from the original medium and transferred it to a different medium. They failed. We can quarrel over whether that's the right or wrong decision, but the important point is this. Exactly the same thing is happening. How do you think your hard disk stores information? Right? It's either magnetic, optical, electrical charges, but something is happening at the molecular level to allow the information to be stored. Okay? But because we are blind to this, we don't see accession working. All right? Many lay people also don't understand how file transfers work. Remember I said if you transfer from two folders within the same medium, it's instantaneous. When you transfer from one medium to another, okay, when you say transfer, you are not really transferring in the normal sense of the word. If I transfer this piece of paper to Dave, Dave has it, I don't, right? But if I transfer a file from one medium to another, what has simply happened is that I've made a copy in the new medium. The file is still in the old medium. Even if I don't see it, when I open the folder, it's still there. The information is all still there. And even if I delete it, I go into the recycle bin, I empty it, it's still there. As Hong Kongers should know from the Edison Chen scandal, he claimed to have deleted all the files on his computer. Remember? But somehow, miraculously, they were all restored. Why? Because they were still there in the hard disk. You would have to reformat your hard disk, write over all the data where the data used to be before it becomes inaccessible. We come now to what I call the terror of possessive pronouns, right? So Dave liked to talk a lot about my Alice's file. Why is it Alice's file? Well, I don't know how many of you have read this article by James Harris about who owns my body. And he criticizes this argument about self-ownership. And I love this quote: the fact that people deploy possessive pronouns in relation to their bodies is in itself no indication of ownership assumptions. My, yours, his, or hers may signify a host of relationships. I have lots of students. If that means I own them, I'm one of the biggest slave owners on earth, right? Unfortunately for me, I don't own my students, okay? So if you substitute the word body with data, exactly the same thing works. What do you mean by Alice's file? Right? So she created it. The information in the file may not belong to her. It might have been copyright infringement. Right? It could have been illegal. It could be child pornography. Right? Is it Alice's? Why do we say it is Alice's? Okay. Now, what is the problem with metaphorical thinking, right? Imagining that what happens in the real world also happens online, right? Like for like, so to speak. Well, in the first place, as I said, the physical process is completely different, right? When I transfer objects, you have it, I don't. When I transfer files, we both have it, right? Even if I may not know how to access it, okay? But we can see the dangers in metaphorical reasoning from old examples. So in common law, unjust enrichment didn't used to be part of the common law for the longest time. It used to be what civilian systems dealt with in terms of restitution. We dealt with quasi ex contractu, as if upon a contract. Now, of course, historically, in the early 20th century, the courts actually believed in the legal fiction itself. And so it said, you know, if you couldn't make the contract, therefore we can't impose this implied contract, therefore no restitution. And it took, 80 years for the court to reverse this position and to realize that it's actually just a metaphor. All right. Now, closer to home, we actually have an English Court of Appeal decision where precisely this sort of thinking led to the wrong outcome. The reasoning was impeccable, but the outcome was wrong. All right. So what happened in Your Response and Data Team? Data Team was a magazine publisher, and they engaged Your Response, which was a database manager, to hold and maintain its database of subscribers, right? At some point, they became dissatisfied with the manager's service and purported to terminate the contract. The parties then couldn't reach an agreement, right? The database manager said, I'm not going to release the database until you pay me. And the magazine publisher said, I'm not going to pay you until you release all my data, right? And so, of course, what do we have? We have a lawsuit. And the way the suit was argued was on the basis of whether your response could exercise a lien over the data. Now, this obviously means the data is property. A lien is a sort of possessory security. The trial judge held that because data team had failed to give adequate notice to terminate, it was in repudiatory breach. Your response was therefore entitled to exercise a lien over the data until the outstanding fees were paid. On appeal, the Court of Appeal, led by Lord Justice Morbick, very reluctantly overruled the trial judge, explaining that, well, even if there was property in data, this property couldn't be tangible and therefore cannot be the subject of a possessory security. A lien is a possessory security. We're talking about a common law lien, not an equitable lien. Now, as I said, this reasoning in property law terms is impeccable, okay? The problem is, by focusing on the property dispute, they have actually missed the crux of the dispute. If you stripped the property analysis from the case, this is a simple contractual case about countervailing promises. And when you have countervailing promises, the question is, does your non-performance excuse my non-performance, or are these promises independent? Typically, outside of the law of leases, the law presumes that they are dependent rather than independent. And therefore, if you don't pay me, I don't have to release the data, right? So the trial judge reached the correct outcome, but by giving the wrong reasons. And the Court of Appeal reached the wrong outcome, but gave the correct reasons. And we could have avoided all of this if we just did not talk about property. Now, a word about a lot of the examples that Dave uses. Dave uses a lot of examples about Alice and Bob, and these are usually very simple examples. Alice creates the file on a computer that she owns, right? And in this sort of examples, it's very easy to lead the audience into thinking the outcome must be that Alice should be able to stop Bob. But let me give you the correct kinds of examples. The correct kinds of examples are actually harder. Suppose Dave and I have the exact same camera, right? So we both use the Fuji X-T5, right? They look exactly the same. By mistake, I take Dave's camera, I snap a few photos, I put it back down. Dave discovers, he picks his own camera up, brings it home. He needs to use the SD card. He finds these strange photos on his camera. Says, I need the space. So he deletes those files. Is he liable to me for conversion of my digital files? I would think that if anybody is liable in tort, I'm liable to him for trespass, right? I took his camera without his permission, right? Now, if you cannot solve these problems, right, where my digital file is on your device, what is my basis for stopping you as the owner of the chattel from doing whatever the hell you want with your chattel? This is a problem I think Dave cannot resolve, right? And finally, a little bit about human flourishing. I don't think human flourishing works in the cyberspace. I think we need things in the real world because, without food, without clothing, life is quite miserable, right? But I think many people would say, particularly Gen Z, that you would flourish more without the internet. It's quite a disgusting place right now. So I'm not sure you can extend the reasoning in the physical world to the cyberspace. All right, so I think with that, I will end. I think that digital files are basically will of the wisps, otherwise known as ignis fatuus in Latin. Thank you.
Thank you so much, Kelvin. I guess at this point, we'll open it up to the floor for questions. If you have a question, please raise your hand, okay? But let me first maybe ask Dave a question. You know, I'm new to this, so a thought that come into my mind. You know, oftentimes when I have a file and I want to change it, right, I might make a copy, right? And so then I have two copies, right? But if I have two copies, is that one file or is that two files, right? Because I think we're just talking about metaphors, and you know, if that is two files, then someone who actually copies your file in essence is just creating a different file, right? So in what sense is that your file?
I'm there. Thank you. So this is a great point. Thank you so much for giving me the opportunity to clarify that. So for me, I would argue that each copy or instance of a file is in fact its own digital file, right? It has its own file name and its own location, right? So you might have 10 copies of a draft, say, that you're working on, right? And I would view each of those as being their own separate file. And you would have a property right in each of those files. Now, if you send me a copy of your file, say maybe you attach it to an email, right? Then in fact, I would argue you are transferring that copy to me. And we can think about your intention when you do so to see whether I now have a new ownership right in that file you sent me, right? You might send it to me with the intention that it is now mine to do with what I want permanently, in which case I would say that is now my file, right? Or you might, if I'm, say, a cloud service provider, upload it to my servers with the intention that I hold it for you on your behalf, right? And so in that case, I would argue that we enter into a kind of virtual bailment, right? In the same way that you can store your goods in my warehouse and I then become a bailee towards you, you could store your digital files on my servers and I would be like a virtual bailee towards you. Does that help classify or clarify that point? Thank you.
Okay, so I believe you have a question.
Thanks. I think that's a great question, right? And I think you're getting to one of the other differences between physical objects and digital files, right? Which is that when it comes to physical objects, typically your possession is indivisible, right? It's unitary. I have it or you have it, right? But with our digital files, because of the way modern computer systems are structured, it's actually typical for several parties to have control over a digital file at the same time, right? The obvious example, as you mentioned, is when you store things in the cloud. I have some degree of control over files I've stored in the cloud. I can access them, I can encrypt them, I can edit them. But obviously the cloud provider, as you put it, has the ultimate control over their servers, right? No matter what level of encryption I apply, the cloud provider can delete my files, right? Or can stop me from accessing. So we have this layered control where I have some level of control and the cloud provider has some level of control. So clearly this is a way in which digital files differ from physical objects. And actually the same will apply to some extent to a lot of your local devices. For example, I say this is my laptop. Actually, it's Queen Mary's laptop, right? And I have control over the files stored there, but so do Queen Mary's IT administrators, right? And if they decide they want to lock me out from this device, then they have an ability to do so, right? And so the question then becomes, what do we do with that fact of layered control? Because we need to recognize it, right? We cannot have a proposal for property rights that does not accommodate the way in which these computer systems actually work in practice. So what I would argue is that we can accommodate that within this notion of property rights, even though it's different from physical objects, right? We could say, yes, you have control and so does your cloud service provider. In fact, that sets up the possibility for conflict. And I would argue that one way to resolve those conflicts is by looking to property rights. So we could structure that relationship between you and your cloud provider as a bailment, right? We could say you own your digital file, and at the same time, the cloud provider owns the underlying servers. You both have some level of control over it, and you both have a possessory title to it. Now, that would be weird, right? New under the law to say two possessory titles at the same time. Kelvin probably hates this, hates everything about this idea. But why I would argue that it is in fact helpful, right, is because the duties of bailees in the physical world make sense for cloud service providers. Duties of reasonable care, duties of return, liability for failure to do so, right? We could impose those duties on cloud providers under the law if we chose to do so. That, I think, in fact, would be beneficial to cloud customers. So I would say, yes, you are right, but there might be ways to accommodate that within the legal system.
Other questions over?
So there's a few issues there. Thank you for your question. I guess the way I would think about that in practice, right, is that a court cannot exercise direct control over digital files any more than the court would exercise direct control over a bicycle which someone has taken from you, right? What the court would do is put in place an order to the person who has taken your bicycle to return it to you on pains of being in contempt of court, suffering fines, etc. At some point, if you really want your bicycle back, you might need to enforce that judgment by paying someone to go and take it from the person who's taken it from you. So in the same way, I would argue that a court could order whoever now has obtained control over your digital files to return it to you on pains of being in contempt of court. So I don't see that problem per se. As to whether this should be contract rather than property, the way I approach this is that it's not strictly an either or question, right? There's a lot of cases in which we both have property rights, which set certain default rules under the law, and we then layer on top of that contractual rights to agree our duties and liability between us, right? So if we think about the cloud service provider for a moment as being a virtual bailee, right? Under bailment law, they have certain duties of care and certain liability. But as with a warehouse, we can then amend those duties by entering into a contract with the cloud service provider, right? So they can disclaim a certain duty of care, take on a separate duty of care, and disclaim liabilities that would otherwise arise so that we could have like a virtual bailment on terms. So I don't see it as being either property or a contract, right? I see those two as being able to play together in ways that create solutions that work for specific circumstances.
So a couple of days ago, when I first met Dave in Hong Kong, he was telling me about his initial plans for his PhD. And it was all going to be about contract. And therein lies the solution, Dave. It's contract. Contract's the answer. Contract's far more flexible than property, right? Many of the problems that, I can't say I know all the examples Dave has come up with, but many of the examples that he has come up with and says that if you don't recognize property, this is a problem, to me are not real problems, right? So if Alice has a file on her computer, Bob deletes it, it's trespass of Alice's computer, not a problem, right? If you put your file on the cloud and your service provider goes bust, right, and you can't access it, it's a contractual claim. And if your service provider uses a different service provider, say Amazon, right, web services, well, then to me, the answer is the same as if you hired a contractor and your contractor hired a subcontractor. The fact that you pay your contractor is neither here nor there vis-a-vis the subcontractor. So the fact you can't get it back, to me, is no greater injustice than the subcontractor refusing to do work for you, right? Then don't use a cloud service provider that uses a third party, right? One of the examples, if I remember correctly, Dave gave was, well, let's say your cloud service provider doesn't use a third party, but have gone bankrupt, right? How do you make sure that the liquidator returns you your files? Well, if you have paid all your dues, why would the liquidator not return you your files? Because if he doesn't, then you now have a claim in insolvency and you're increasing the burdens on the rest of them. So to me, there are no real problems once you understand, the kind of situations that can arise. And of course, then you don't create the kinds of problems that I posed, right? I use your computer to store a file. Why should I be able to stop you from now deleting the file? What if you can't find me? You need the hard disk space. What, you've got to keep the file forever? Involuntary bailment?
So I'll just respond to that, if I may, and I'll respond actually to that last point, which I think is one of those helpful examples of thinking through this issue, right? And I would say that what you said at the end is exactly how I would treat that issue. I would say this is a case of involuntary bailment, right? If you go out into your garden and you find a football in your garden that you haven't seen before, that I would say is analogous to the situation of finding, say, your photographs on my camera or your files on my USB stick. So what does the law say you have to do? Do you have to keep that football forever? No. You have a duty of reasonable care towards somebody else, but it's reasonable care. Maybe you need to think, oh, is there another kid in this neighborhood who might have kicked the football into my garden? Maybe I'll keep it for a few days if somebody comes to collect it. And if not, once you've exercised your duty of reasonable care, you are fully entitled to delete it. If I come across your files on my computer or on my camera, and I see there are beautiful selfies of you, standing on top of Victoria Peak, I don't think I should have the right to immediately delete them, right? Now, let's say I don't know you, right? As you say, oh gosh, this is weird. What are these files are doing here? Maybe I should wait a few days, right? Maybe if I want the space on my camera, I make copies on my local computer. Storage is cheap, right? I can store them for a few days at no huge cost to myself. So I think, again, by looking at the way in which we treat tangible solutions, we can apply the same rules and find reasonable solutions. Okay, I mean, that's fine. I guess when it would be obvious to me, from a legal perspective, right, is if there were a Supreme Court case saying there's no such thing as involuntary bailment, and so these obligations cannot arise as a matter of law, right? Then I would say that's obvious. We might still disagree with that Supreme Court case, but it would be obvious. As to whether we can have a legally enforceable duty in that situation, right? I think there are some people who would say no. The only way for legally enforceable duties to arise is through people voluntarily undertaking them, right? The law has no place in imposing these duties on an involuntary bailee. And to that, I would respond, that's too limited, right? As a community, we can expect others to undertake reasonable care of our property. That doesn't have to be voluntarily adopted by the person facing that duty.
Yeah, so I have a question for you, Dave, right? Suppose you use my camera by mistake. I find your files. I don't realize they're your files because, I have so many photos on my camera. I maybe think this was something I took, 3 vacations ago. And, they're not terribly good photos. I need the space. I delete them. Am I liable?
Kelvin? I will sue you for damages. The court will tell us whether you're. No, I mean, look, I think this is a great example, right, of why actually conversion is quite a harsh tort, right? Because it applies to any deliberate interference, however reasonable or acceptable it might seem in the circumstances. This is a problem with the tort of conversion as it applies to physical objects as well. Just because we're not happy with the way the tort of conversion applies to physical objects doesn't mean we should not extend protection to digital assets. Actually, what we should do is improve the tort of conversion for both physical objects and digital assets to ensure just outcomes in both cases.
So this is where I have a problem. The reason why the tort of conversion and all the other property torts behave like that is because you have the erga omnes right against everyone, which is why any deliberate interference, however innocent, is a tort. If you start making it fault-based, it's no longer property. It then becomes a fault-based tort. You no longer have exclusive control over the thing. So you're denaturing conversion if you make fault an element. So I know you refer sometimes to defenses, but when we talk about defenses in the law of property, we're talking about bona fide acquisition. So you must be an acquirer, and it's not really a defense. It's a priority dispute resolution mechanism to give someone else who is acquiring from a non-owner superior rights. So it's not a defense to a tort. There is, I mean, the defenses available for interferences with property are very limited necessity, right? If I need to destroy your house to save, David's life, yes. But if I think that's my house, no. However, reasonable my belief.
You're absolutely right to point out that we have these other areas of the law that already apply to computer systems and to the information contained within digital files, right? You started by pointing to criminal offenses, right? Misuse of computer systems, obtaining unauthorized access to somebody else's computer system is already a criminal offense, right? You're absolutely right in that sense. And you pointed to, for example, copyright that you have in the content of the files that you store. So the photographs on the camera, I've already got a copyright in them, right? And so we already have these other areas of the law. And I also think actually that Kelvin is right when he says we can be creative lawyers, right? We can think of ways in which those other protections can help in these instances, right? What I would say in response is that actually we've seen criminal law and copyright law respond quite well to modern digital environments, right? We've updated our criminal code with these new computer misuse offenses, and we've applied copyright law to digital copying in a way that actually works pretty well. But it doesn't necessarily resolve all of the situations which I'm talking about here, right? So in that cloud scenario that I talked about, Alice stores her file in the cloud. Let's say it's copyright protected, right? It's a photograph she's taken, beautiful photo. When Bob obtains access to that file, he is committing a criminal offense, right? That is misuse of a computer system because he's obtaining unauthorized access, clear under criminal law. Deleting that file, I'm not so sure is clear under copyright law. Copyright law incorporates copying. It's not clear to me that it offers protection from deletion of your copies, right? So if he took a copy and stored it separately, we might argue, oh, he's infringing your copy. But merely deleting the file doesn't give you a right against Bob from a copyright perspective, right? Equally, the fact that he's committing a criminal offense doesn't give me a right to sue him for damages immediately, right? That is an offense that could be prosecuted before the courts, but it doesn't necessarily give me the civil remedy that I need. And lastly, my contract there is with Amazon. Bob is a third party completely outside of that contract. So it's not clear to me how I could rely on a contractual remedy to seek damages from Bob.
So I just want to kind of back Dave up slightly by saying that not all the solutions will necessarily be satisfactory to you. And there is clearly scope for the law to intervene. I just don't think property law is the right tool, right? So it's up to Parliament, legislature, to design new rights that won't interfere with pre-existing ones, right? That doesn't impose duties on owners of chattels who find strange files on their computers to start, taking care of those files. I'm not sure what can be done, in that example. I mean, it's quite clear Amazon would be able to sue Bob for trespass, because that is a clear trespass on Amazon's servers. But Amazon may suffer no losses because Amazon may owe no duties to Alice, right? So this is one of those examples, if you remember from your contract law days, black hole theory. The person that suffers the loss has no right. The person with the right suffers no loss, right? So can we invent a solution? I don't know, but I'm pretty sure as a property lawyer, I don't want that solution to be property.
Okay, we're almost at time of this very exciting debate. Are there any last interventions at this point? Yeah.
So I think one of the problems with that idea, so one reason why property is so controversial, and which is why you don't actually see courts creating new forms of property for centuries. Most new property are statutorily created because, at least in democracies, the idea that non-democratically elected public officials are creating property is problematic is precisely because property rights affect everybody. A's rights is an imposition on everybody else's liberties. So even if you say that what you are trying to create is duties on everyone, you don't call it property, same problem arises, right? Which is why I think this is something that is for the legislature, not for the courts. Because again, democratic process, if you live in a democracy, and also courts are not in the best of positions to consider the kind of policy implications beyond the facts at hand, right? So they can't see the knock-on effects. If I decide this case this way, what will the effect be on the next case and the next case after that? This is something that legislatures in a much better position to do, right? So you could, have a legislature create a freestanding tort that had a mental element, right, which was erga omnes. I would be a lot more comfortable with that.
I think that's a really good answer, actually. I don't have too much to add. I guess the only thing I would say is that, we can think of these new situations by applying different areas of the law, right? We can say, oh, maybe this is a contractual issue, or maybe this is a property issue, maybe it's a tort issue. And those are all different tools that we have as lawyers to try and resolve this issue. And we can disagree about what is the appropriate tool, as you've heard today. As to whether we should turn to the legislature in order to develop those new solutions, I think the legislature has certain advantages, right? As you say, they can look beyond the issues of a particular case, think more about long-term solutions, and maybe weigh up competing interests that aren't reflected in a particular case. I would say that the legislature also has certain disadvantages. I don't know what LegCo is busy with today, but in the UK, there are all sorts of things being discussed in Parliament that unfortunately do not help us resolve these commercial disputes, right? So I would say that if a certain case comes before the English courts and the parties argue it in ways that involve property rights, then that should be one of the tools available to the court to resolve the dispute.
Okay, thank you so much. So we've come to the end of this debate, and I guess the true winner, of course, is the audience. So thank you so much, Dave and Kelvin, for this intellectual feast. Thank you so much.